Good afternoon, everyone. Thank you for joining us for our monthly webinar today, the very popular Compliance 101 with our Executive Director, Mike Lunati. Just a few housekeeping items. On the screen in front of you, you will see a red number in the bottom right-hand corner. The number is 24. Please write that down in case there are any questions as to whether you were on the webinar or not. So that's number 24, bottom right-hand corner in red. Once this webinar is over, please allow 7 to 10 business days for your portal to reflect your credit, and you will receive a notification in the mail. If you disconnect at all during this webinar and you can't get back on, or you do get back on, or you're just not sure, please email us immediately and let us know you're having issues or you are not having issues, but you did disconnect and you're back on and you just want to make sure that we have the information correct. If you are using the app on your iPhone, oh, I just got out of there. What happened there? If you are using the app on your iPhone, you will want to make sure that you let us know. Make sure you are on the entire time because we are having some difficulty with that particular platform. All the other platforms seems to work, but the recording system for the app on the iPhone gets a little bit tricky at times. Please make sure you listed everybody who is on the webinar listening with you when you logged in and registered. We need this information for our report to make sure that we have everyone at the time. Okay, I'll say it once again. Please record that number that's on the bottom right-hand side of your screen right now, 24, in case you are asked for that. At this time, I'm going to turn it over to Mike. Thanks, Mike.
Thanks, Kelly. Good afternoon, everybody. Thank you for spending some time with us today to talk about compliance. As Kelly mentioned, very popular session for us. This session actually came into being a couple of years ago when we decided to try a new format and did this Q&A where we take actual questions we get from you guys as our members. As Kelly mentioned, it's become one of our most highly attended sessions. And since we get new questions all the time, the content remains very relevant. So if you've participated before, you already know how this works. But for any first timers out there, here's the format. What I'm going to do on the slides is I'll read a question or pose a scenario. I'm just going to give you a couple of seconds to think about it, and then I will give you the answer. Each slide will also indicate the source of the answer at the bottom of the page. We have 56 to get through, so without further ado, let's get started so we have some time for questions at the end. So first, we're going to look at funeral home business operations as a category, and we have a couple questions and scenarios in there for you. First one is, can a funeral home charge more for embalming tissue or organ donor remains? Yes. You're usually going to use the heading restoration, and it's going to be listed under other preparation of remains. So that is something you are allowed to do. Can a funeral home offer a discount for veterans? Once again, this is something that is permissible. And then again, to ensure you're not doing anything discriminatory, you have to make sure that you're offering it to all veterans and that you are including that on your GPL. Next, is it permissible to take selfies during funeral services? So nothing in the law or regulations that addresses this either way. So basically the recommendation and the guidance from the department is that the family should make their wishes known to the funeral firm. And if the family does not wish to allow this, the firm should post a sign or notice stating no picture taking. So again, this is a question that came up, and it was obviously from a non-family member that was bringing this up to the family and the funeral home. Next. Can a funeral home offer airplane bottles of liquor as a favor at a celebration of life if the bottles are passed out as people are leaving and guests are instructed to remember that the person once they are home? The family would be purchasing and providing the bottles, although the funeral home employees would be passing them out. So this is one that is not permissible. If you want to let the family pass them out and have the funeral home make it clear that it cannot be consumed on site, it can be handed out, but the funeral staff cannot be involved in passing anything out. While it's not explicitly listed anywhere in the law, it is based on the food and beverage law. Again, not explicitly stated that way, but based on that law, that's where this prohibition comes from. Next, many casket suppliers are imposing surcharges on funeral directors who purchase caskets and urns from them. While that surcharge cannot be passed along to the consumer as a surcharge, are there any instances where a funeral home can list a surcharge for merchandise as a cash advance? You are not allowed to do that. The only way you could is to call it a gratuity and then give the customer the option to decline to pay it. So it can't be a cash advance that's a required payment. It's part of the wholesale cost of whatever merchandise is being sold, and the GPL should be changed to recover the cost. So even if it's listed as a surcharge in your invoice, the total price should be changed on the GPL to do it that way instead. Next, does state law provide any tax exemptions for funeral service? It does. Goods and merchandise that you sell to a family at the retail level are exempt from New York State sales tax. However, when you guys are buying stuff for your funeral home, that is considered a wholesale purchase and is subject to sales tax. Or if you have something that's not tangible in nature, physical in nature, any funeral service that's in that category is not exempt and is subject to sales tax. So goods and merchandise sold to a family are exempt. Funeral services that are not tangible, physical in nature are not exempt. And anything you buy for the funeral home from a supplier is considered a wholesale purchase and not exempt. Can a funeral firm offer a price match guarantee in which the firm promises to match the GPL price of a competitor? No, this is one that was on our very first Compliance 101 session. You can see there that it was back in 2019 that the Bureau issued formal guidance on this. But this one is one that we feel is important enough to keep on there. So even though it's kind of one of those oldies but goodies. So based on that 2019 guidance letter, which cites both federal and state law and regs, requiring the GPL to have prices for all funeral goods and services regularly offered. Prices should be static until updated or amended, at which time the GPL is provided with a date stamp so families are clear which prices are applicable on that date. So you have to abide by your GPL prices. So you can't just offer to match a competitor's price. You have to offer the price that is on your GPL, other than the things like we just talked about where you could have a veteran's discount or something along those lines. But a price match guarantee is not permissible. Can a funeral firm impose a late charge for past due monies owed? If so, is it subject to the 16% usury rate? So, yes, you are allowed to impose a late charge. However, you have to give notice to the consumers prior to that. So in your agreement with them, it has to say that late payments are subject to a late fee of, and it could be a dollar amount, it could be stated as a percentage. However, you are not limited to the 16% usury rate. That usury rate actually applies to loans. The criminal usury rate is a higher rate, which is at 25% per year, which equates to approximately just over 2% per month. So if you want to impose late charges for fees that are overdue, you can do it up to 25% per year, or you can include a 2.08% late fee per month. But that is permissible under state law, federal law, and the regs. All right, our first scenario. A woman wants to rent out a random funeral home to have a memorial service for a friend. No body will be present. The deceased had been cremated a few months earlier, and the body was taken care of by another funeral home. The service would not be approved by the family. Does the funeral director have any liability if he rents out the place? So the type of liability that the funeral director or the funeral home will have is basically the liability you would have for slip and fall or something else. So like people on your premises and those things. If the group wants to rent the facilities to hold a memorial service that you didn't, for someone you didn't cremate, there will be no body or cremains, and the next of kin didn't authorize it, then the funeral home is free to rent the facilities to whomever you'd like to. So you are allowed to do that, and especially under these specific circumstances where you haven't been involved in the cremation, there is no cremains or body, and next of kin is not notified. But the liability you have would be under your general liability policy, which related to accidents that might take place. There is no specific liability for taking this step. Are funeral homes allowed to store bodies for another unaffiliated funeral home in their storage facilities? Yes, that is something that you are allowed to do. If you are going to offer that, it should be on your GPO. If you're offering it and it's on your GPL and you subcontract to another firm, there's no issue. It's also important to note that prior administration at the Bureau of Funeral Directing had an opposite view, but this has been longstanding since Mr. Fuller took over. So are you allowed to store bodies for another unaffiliated funeral home in your facilities? Yes, you are, under the way it's written there. If the firm offers it on their GPL and subcontracts to another firm that leases them the refrigeration space, there is no issue at all. Is there a specific time frame a funeral home must replace or rename a manager, and if when their current manager leaves? So when your manager leaves, do you have a certain period of time when you have to name the new funeral home? Yes. Under the regs, 77.8F, you have 10 days to appoint a temporary manager and 90 days to complete registering a new manager. Next, can a funeral home in New York State charge an extra $250 to make a removal after 5 p.m.? Okay, so there's a lot here that was given. So I'm not going to read this verbatim. The answer, though, is no, you cannot. The rationale, this goes back to the extra person removal fee that's prohibited as well. Because we have package pricing that is required under GPLs, and the package price includes the transfer and forwarding and receiving of remains, then you can't have a la carte for the things that are part of the package pricing. So it has to be included, and it cannot be an extra charge. The specific reg 78.4E2 does say that the price for transfer includes personnel, equipment, and vehicle. There's nothing that differentiates it based on when someone happens to die. And the Bureau also pointed out that they felt that that would open up the possibility of abuse by the firm, who might decide to wait to pick up a body in order to get that extra $250 after the 5 p.m. or whatever after hours time they used. So this is not something that is permissible. What rights does a funeral director have when they are in possession of remains and the family refuses to move forward? So in this situation, you can give the family a deadline, at which point you declare the body abandoned and then turn it over to the county medical examiner for disposal or disposition. So that's the answer. Practically speaking, we recognize that from the calls we get that is problematic at many times when getting the body turned over is difficult. But that is your legal right per the Bureau. And you can also, as you probably know, bill whoever gave you permission for the transfer for the services you had rendered to that point. Does New York require that certain funeral home support staff be paid at specific intervals? It actually does. The New York labor law requires companies employing quote unquote manual workers to pay those folks every week. The definition of a manual worker can include workers who spend at least a quarter of their time engaging in physical labor, which includes common tasks like sweeping, carrying, and standing for long periods of time. So if your staff are engaged in work that would be deemed manual labor or manual work for at least a quarter of their time, they have to be paid weekly. This law has actually been around for a very long time, but had not been interpreted this way until 2019, when a New York appellate court ruled that paying manual workers less frequently than weekly triggered damages, even though they were getting paid the same amount. It was the frequency in which they were being paid that caused the problem. This had popped up in some funeral homes in New York State, where folks did take action against the funeral home for not paying them weekly, paying them on payroll biweekly. So we want to make sure that everyone's aware that this is a law that has been interpreted in a way that you need to pay manual workers on a weekly basis. All right, we're going to flip from business operations over to pre-need. And our first question in this category is, when should a person establish an irrevocable pre-need account? Okay, so most of you probably know this, but under New York law, if an individual is an applicant or recipient of Medicaid or SSI, they have to open up an irrevocable pre-need account. The irrevocables are used for the spend down purpose to help determine your eligibility for either of those programs. So you would have to open it there. In 2011, that law was changed, where you can also, under certain circumstances, open irrevocable accounts for others who are deemed family members. And there was a very specific list of the types of individuals who would qualify as family members, where that person can also open up irrevocable pre-needs to help with the spend down process. I think I have a note for you at the bottom there, because this has come up from in the past. We have had situations where somebody opens up an account and they try to open up a second irrevocable at a different place to kind of spend down further. The Medicaid law is very specific. An individual may only have one pre-need account. So that is something that every once in a while we find triggered, where someone's opened two or trying to get away with opening two. So you may only have one for yourself or any person that you open it for. All right, so I just said it's very specific as to the type of family member. So who are the family members that you're allowed to open it for? So that those people include your spouse, your children, minor or adult, including adoptive and stepchildren, siblings, parents, adoptive parents, and the spouses of those individuals. So it's meant to be immediate family and a little bit beyond your immediate family. If there are funds remaining in an irrevocable account after all funeral expenses have been paid, who receives the overage? So, as I'm sure most of you also know, any overage remaining in an irrevocable account after everything's been performed must be forwarded directly to the social service office in the county where the beneficiary resided at the time of death. So nothing can go back to the family members. It has to go back to DSS. Next, can an overage in an irrevocable pre-need trust account be used to fund additional service or merchandise? It cannot. So when you have an irrevocable pre-need, including the ones for family members, any funds remaining have to go to the social service office, as I just said. The related question we get is whether changes can be made to an irrevocable agreement. So the answer to that is yes, the purchaser can make changes pre-need, not at need, pre-need. And in an irrevocable agreement, the changes have to be of equal or lesser value. The reason is you got approved for Medicaid. You are now, maybe you think, the person thinks, oh, I have some extra money. I don't want it to go to DSS when I die. I'm going to add things to my irrevocable account. But because you've been approved at that amount and they've already excluded what you had in your original agreement, you can't add more to it, because ultimately that would mean you would be taking money that would go back to the state and using it on the funeral service. Can a funeral home or funeral director be designated as the beneficiary of a life insurance policy? They cannot. The insurance law in New York State prohibits a funeral director and a funeral home, either one, from being designated as the beneficiary. Now, upon death, however, a policy can be assigned to a funeral home by the policyholder after the policyholder dies. And we know that happens quite often. But you can't be designated as the beneficiary, but you can have the policy assigned to you after the person passes. Can a funeral director serve as the agent for a friend who has a family? And I should have noted that we now moved from pre-need over to our next category, which is final disposition. So can a funeral director serve as the agent for a friend who has no family? Yes. So a funeral director can serve as an agent. However, anytime a funeral director is serving as an agent, they cannot be compensated or receive any kind of financial benefit. So you would be doing the services for gratis. Even if you're not the owner of the funeral home, if you're an employee, the funeral home cannot charge the family for the services if the funeral director is serving as the agent. However, funeral directors are entitled to serve as witnesses on the agent form, and there is no prohibition with regard to compensation when it comes to serving as a witness. Do foster parents have the right to control disposition of a foster child who passes away? All right, so this is maybe. So if the foster parents have legally adopted the child, and if you are legally adopted the child, a child is number 4 on the hierarchy list under 4201. That would be one way. Or if the foster parents have been officially appointed guardians by a court, which is number 6 on the list, then they would have status to serve in that role of controlling disposition, assuming there's nobody higher up on the list available. But as a foster parent themselves, they are not entitled. They would have to have one of these two situations also take place. If a biological daughter of the decedent was adopted by another family before the decedent's death, is she still considered a child for purposes of the priority list? So, the way the law works, once someone is legally adopted, the adoptive parents are now her legal parents, and all the parental rights that you had through your biological relationship are transferred over to the adoptive parents. So, in this case, if the biological daughter is adopted by another family, she would not be deemed a daughter for the decedent's death of that family member later on. And as we always say, this is the Bureau's answer, but whenever we have issues, when there's legal challenges involved, as you know, if you've spoken to any of us here when we're answering your questions, we always say, take a breath, tell the family to either go to court if there's going to be a dispute like this and get a court order, or come to an agreement and put it in writing so that we can move forward. We always decide to take that, err on the side of caution and take that conservative approach. All right, are stepchildren considered children when it comes to the final disposition law? Now we know stepchildren are considered family members when it comes to opening up an irrevocable pre-need. However, they are not considered children when it comes to the final disposition law. And the reason for that is that there is no legally recognized relationship when it comes to stepchildren, in the sense that they are not heirs nor descendants. So that relationship is only created if they are adopted. So a stepchild is not considered a child for purposes of the final disposition law. If a child is accused, not charged, with a killing of a parent, do they need to sign the cremation authorization forms? You could also say, are they allowed to sign the cremation authorization forms? And in either case, the answer is no. So, a related question we get to this, because this one's specific to the cremation authorization form, is do they have the right to control disposition? So would the child of an accused of murdering or killing her parent be allowed? And the answer is that no, in this case they wouldn't, because the 4201 language states that if the person is charged or arrested in connection with the death, they can still serve as the person in control, right? So if you're charged or arrested in connection with the death, you're removed from the ability to control disposition. So in this case, we have a child who is accused but not charged, so that child would still be authorized, in this case, to serve in the role if there was nobody above them. Again, if that turned into being charged, then they would be disqualified. All right, our next scenario. An under 18-year-old mother dies. Let me start that over. An under 18-year-old mother's child dies. Does the mother have the right to control disposition, or is the fact that she is under 18 prevent her from doing so? So we don't have a lot of definitions in the public health law when it comes to funeral service, but 4201 does have a couple of definitions, and one of them is defining the word person. And as you can see here, a person is defined as someone 18 years of older. And then it goes on to say, after the definitions, the following persons in descending order shall have the right to control the disposition. So in this case, since the mother is not 18, she is not legally a person for purposes of the law and is not deemed the mom for purposes of the hierarchy list. If a couple is separated, not divorced, separated, is the surviving spouse still the next of kin? So unless there's an agent, yes, they are still spouses under the law until they are legally divorced. There's some things about separation. So what happens with a separation in New York is it's a court order that's usually accompanied by a separation agreement. And the agreement's really set up to deal with things like dividing property, setting up arrangements for raising children. It clarifies that financial arrangements are no longer tied together and separates those. However, it does not in that agreement anywhere dissolve or end the marriage. So they are still spouses unless they become divorced. Does a person need an attorney or notary public when filling out an agent designation form? You do not need either of those individuals, but you will need 2 witnesses. Next, can an individual appointed as the agent also serve as one of the 2 witnesses on the agent designation form? So basically, yeah, can you serve as the agent and a witness? Sure. There's nothing in the health law that would prevent someone from acting in both those roles. Next, can a person named as power of attorney appoint themselves as the agent to control final disposition? That is not permissible. So this has been kind of a question that has been back and forth several times. I think it was brought up by Tom Fuller in his webinar very recently that he did for us, which we followed up with him because he confirmed with us that what we thought we heard, if he did say it, was a misstatement. There has been an opinion issued by the department's legal affairs team that deals with POAs and the agent form. And the opinion is that the agent form is considered a testamentary instrument, like a will would be. That's another testamentary instrument. And a power of attorney is prohibited from creating or modifying a testamentary instrument. Like a will, right? If somebody creates a will, somebody else can't change the will. It's the person's, at the beginning saying, I'm of sound mind and body. So only the person who's dealing with something that's testamentary in nature can make an appointment, make a declaration, express their wishes. So a POA cannot appoint themselves, nor can they appoint someone else as the agent. Next, if a person completes the agent designation form in another state, or they're maybe a resident of another state, but they're going to use a New York funeral home and be cremated or buried in New York, is that agent form still valid and enforceable? So they completed the agent form in another state, but it's still the New York form. Yeah. So it doesn't matter where it's signed, but here's the flip side of that. If the decedent had signed a New York form, but then they're going to go and use a non-New York funeral home, and it's not going to, then there's no requirement that that funeral home follow the form. The form is specific to New York State, and it applies when you're using it in New York State. Is a funeral director required to obtain documentation of proof of a domestic partnership? So the quick answer to this one is no. You are not required to do that. While this isn't an official answer anywhere, I'm going to go off script and give you my opinion. This is partially based on my experience having been here for a while now, and also being an attorney and looking at how this can be interpreted and what could happen if you don't have proof. So here's my opinion. To protect yourself from liability, I'm going to say I recommend that you have to have at least a reasonable belief that a domestic partnership exists. And this is particularly true if you think it might be or already is being contested. So there's a couple of ways a domestic partnership can be created in New York. You could be a party to an actual domestic partnership agreement, which is permissible in New York and under federal law. You can register as a domestic partner. Many municipalities actually have a registrant right now, so does the state of New York. If you're a named beneficiary of the person who passed, whether it relates to their employment benefits or health insurance, that's proof of domestic partnership. And then the one that's most commonly used is the one we call the totality of the circumstances. So it's things like, we shared income, we owned a house together or a car together, we are both named under the lease, we have kids together, the length, if it's a long period of time in kind of coordination with other things, that would help. So the bottom line is, we always say, is there something you can show that proves that you guys were not just roommates and you were living together as a single household unit? And so that should be pretty easy to show, right? I mean, if you do have a mortgage, if you do have bank accounts where they're jointly owned, utility bills, anything like that. I'm not saying go crazy, but if someone just walks in and claims to be the domestic partner and you just take their word for it, and then all of a sudden a spouse shows up, it can become a little tricky and you're going to be dragged into court. And I'm going to say that they're going to say, hey, did you ask for anything, for proof? They're probably going to, you're going to say no. Now, that can definitely create legal liability. No. Does it water down your defense? Absolutely. So that one extra step lots of times will uncover some things that make it very easy to know whether it is or isn't, or will cast doubt. And if there is doubt and there's possible controversy, you can pause then and tell the individual that you need proof, whether that's through a court or some other way that you feel comfortable moving forward. Again, you're not legally required to do this, but that is my recommendation for moving forward when it comes to determining domestic partnerships. Can a designated agent refuse to serve at the time of need? They can absolutely do that. There's actually a provision in the law that says that you go down this list. However, if the person named is unwilling, unavailable, or not competent to serve, then you go down to the next person on the priority list, or across the line, a line if there's multiple siblings or those types of things where you can slide. But a person does have the right to refuse to serve at the time of need. All right, our next scenario. A man dies who has been in a group home, and it's going to be a direct cremation. His mom is still alive, but is in a nursing home with Alzheimer's. She has a significant other who is her power of attorney. There's also a living aunt and uncle who would be willing to sign. Who should sign the cremation authorization form? It is the aunt or uncle who should sign. So a significant other is not legally recognized anywhere on the hierarchy form. Boyfriends, girlfriends, none of those things are there, only a domestic partner. So your significant other, who is not your domestic partner and not your spouse, has no standing. Being a POA, as we already said, POAs, that only lasts until the person is alive, so the POA ends at the time of death, so there's no relevance to that. So it is the aunt or uncle who should be signing the cremation authorization form. Our next scenario, an adult child without a spouse or children passes away and has been estranged from her parents since she was 12. Moving from another country to the U.S., the parents stayed in the other country. Her brother is willing to sign the cremation authorization. However, her parents are reachable but do not speak English. Who should sign the cremation authorization form? So the parents are higher on the hierarchy list than the brother. And since the parents are reachable, the next in line doesn't apply, right? So it's unwilling, unavailable, they are available. So the brother would need to reach out and either have the parents waive their rights or work with them to have them sign the cremation authorization form. Another scenario. A decedent has a brother and nieces as next of kin. The nieces tell the funeral director that their uncle has disowned the family and either won't share or don't have any contact information for the uncle or brother. If the nieces say they don't have contact information and or aren't willing to share, can the funeral director move down the priority list and work with the nieces, or is there some other independent action the funeral director has to take to try and connect the brother or to contact the brother before being able to say he was not available after making reasonable efforts to reach him? So this is that unavailable question, basically, before you can move down. So in this scenario, if the nieces are willing to sign the at-need statement that the brother is not reasonably available, unwilling, or not competent to serve, and is not expected to become reasonably available, then the nieces can claim the right to control disposition of the decedent's remains. It's not your job as funeral directors to determine what the status of the brother is. If the funeral director has a written statement and is acting in good faith, you're protected from liability. So again, you're not an investigator, right? So there's not an obligation to force people to give you information or to try to find these people that's beyond reasonableness. Reasonable is asking the nieces if they have contact information that they can share. And if they say no, then they're on the hook for having said there is nothing and there's nobody available except us. So that is your protection. All right, we're going to swing from, we have just one question on disinterring an urn that came up. And the scenario is a court order required to move an urn from a public cemetery niche? So removal of cremains requires the same consents as removal of bodies, except you don't need a funeral director even if you leave the cemetery. So to do a disinterment, you need consent of all lot owners, any living spouse, adult child, or parent of the deceased, and the cemetery itself. The cemetery does not have to consent just because the first two provided their consent, and absent any of these required consents, you need a court order. And that is based on both speaking with the Division of Cemeteries, who oversee cemeteries in New York State, and the not-for-profit law. Flipping over for a couple of slides on death certificates. First, who is entitled to a copy of a death certificate? So the law has a list of people who are. You can see that there. Person, the agent, the spouse, domestic partner, child, siblings, parents, and lawful representatives. In addition, if someone claims to have a legitimate need, they can apply to the local registrar for the copy, and the registrar or a court is going to determine ultimately whether there is a legitimate need by this other person. But that's just that list that is listed, the names or the categories that are listed here on this slide are the people who have the right to a copy. All right, a scenario. A mother lost her fetus at 14 weeks gestation while at a hospital. The hospital will only release the remains to a funeral director. In this scenario, the mom wanted to take the remains with her. The funeral home was previously advised that a fetus that had reached at least 13 weeks gestation will be issued a death certificate. So the question beyond that that came from this is the process of filing for and issuing certificate in this scenario the same as a regular process? Okay, so we went back to the Bureau of Vital Records, and here's how this plays out. So regardless of gestational age, a fetal death certificate is to be filed for the event. If it's over 20 weeks gestational age, the funeral director is required to be involved with the disposition. If it's under 20 weeks, a funeral director is not required. That's usually handled internally at the hospital. If the disposition is taking place outside of the hospital, the funeral director may be needed to handle the disposition and obtain the burial transit permit. In the situation that we set up here, the Bureau of Vital Records said that without knowing the mother's intentions, that a funeral director is going to be needed to handle the disposition. So you would need to speak with the individuals involved, the parents, the mom, to find out what the intentions are. But the 20-week mark is the one that changes the responsibilities of and changes the process and the responsibilities of the funeral director. Next, if someone was legally adopted, do their adoptive parents' names go on the death certificate, or should you use the birth parents' names? So just like we talked about earlier with adoptive parents, the biological relationship is legally severed once adopted. So the adoptive parents at this point are considered the decedent's parents, and it's them who should go on the death certificate. Does a registrar have a specific amount of time to issue a death certificate? Okay, so as you know, under the law, a death certificate is supposed to be registered within 72 hours after death. However, neither the law nor EDRS policies or procedures specify a time frame for a registrar to issue a certificate. Issue meaning the same thing as asking for a certified copy. The Bureau of Vital Records said that if you're unable to get in touch with a registrar and it's taking longer than a week to get a death certificate issued, that the funeral director should email the helpline at edrs@health.ny.gov. So now we're going to flip over to a couple of questions on return of cremains. Is a funeral director responsible for ensuring an individual's intentions per the customer's designation of intention form is carried out when it comes to distributing and sharing cremains? You are not. A funeral director should make sure that the designation of intentions form includes a named individual that you can return the cremains to, and you are responsible for returning it to that person, but not ensuring anything beyond that. So whether that person carries out the intentions or not is not the responsibility of the funeral director. Can a funeral director charge a refundable fee for storing cremains until picked up by a designated individual or the designated individual? You cannot. So it's impermissible to charge a storage fee or a fee for disposing of cremains as indicated after the 120 days have passed. So the law lets you dispose of them after 120 days, but you cannot charge someone for doing that, nor can you charge a storage fee while holding them for that period of time. Can a funeral home refuse to return cremains until a bill is fully paid? If you can, and the customer has filed for Chapter 7 bankruptcy, would that have any impact on the answer? Well, you don't have to get to Part 2 because Part 1 is no. You are not allowed to refuse. You are not allowed to not return cremains. You cannot refuse to do so. They do not belong to the funeral home. The designation of intention should cover where they would go, and regardless of a customer's financial situation or other issues, the remains of the loved one cannot be held until payment is made. What options exist for a funeral director who wishes to dispose of unclaimed remains that date back to before the implementation of the designation of intentions form? So in this case, you have to go to the public health law and 4202, which is the relevant section. In that section of the law, it allows for disposal by placement in a tomb, mausoleum, crypt, niche, or a columbarium, burial in a cemetery, or scattering of the remains at sea, or by otherwise disposing of remains as provided by rule of the department. So in this scenario, scattering remains would not be permissible, but those other forms of disposal are fine. In addition, a record of the disposition should be made and kept by the person making the disposition, and then upon disposing of the remains in the manner that is described there, you are discharged from any legal liability or any other liability in relation to the remains. And that is all listed under 4202 in the law, the public health law. Can a funeral director pronounce a death? And we have now moved over to from cremains to funeral director's duties. So a funeral director is permitted to pronounce a death. You just can't certify a death. The pronouncement is simply is limited to simply setting the time of death. So EMTs, police, etc., those folks can set the time of death or pronounce a death as well. So long as the funeral director is following the law's prescribed text, then there's proof of good faith, and that gives you liability protection. And again, while you are allowed to pronounce a death, you cannot be forced to do so. So, for example, hospice cannot require the funeral director be available to pronounce the death if they're not going to be available or if they just want you to be there instead. So you are allowed to pronounce, you're not required to pronounce, but you cannot certify the death. And if you pronounce, you should use the test as listed in the public health law. Is a funeral director required to supervise the interment of cremated remains at a cemetery? You are not. Burial of ashes is not a final disposition, as that took place at the crematory. The way it was described to us from the Bureau was that no cemetery would ever be given a burial permit for this. The rule of thumb per the department is to put any place you would need to produce or hand over a burial or transit permit, a funeral director is required, i.e. cemetery for burial, crematory for body delivery, or common carrier. A scenario. A woman is on hospice and the family contacts the funeral director and says, we have a family cemetery on our property and we want a green burial. To them, this means the person dies, they dress her up, put her in a shroud, and bury her. They know they need a funeral director to help file the death certificate. Does the funeral director need to be involved with the body for any reason and or be at the family cemetery for burial? So the funeral director actually should be at the burial. That is required. A footnote which we were told about is, as far as the itemization statement, the funeral director should only charge for a direct burial where the family provides the alternative container. In this scenario was just the shroud. So you have to be at the burial, and there's that little footnote in terms of, in this scenario, how you would charge for things. Another scenario, a woman is planning to pass in her house and doesn't want to be moved from there. She wants the funeral director to bring the casket and have the services at the house. Is this permissible? It is not permissible. Any preparation of the deceased for final disposition must take place in the funeral home's prep room. All right, we're going to flip over to our next category, which is GPLs. It happens to be our final category, so we're in the home stretch. First, when listing the direct cremation package price, does it have to include all mileage, or can the mileage be listed separately as in the reg? Does it matter if the mileage is for removal or transporting to the crematory or cemetery? Okay, so mileage is the only thing that can be adjusted in the cremation package, which is what is included when they refer to 79.4. That's the package pricing. The Bureau says if you use one crematory regularly, you should build it into the package, but it is something you can adjust. If it's for the transfer of remains, it can be adjusted based on the mileage prices you have on the GPL, and then obviously you must disclose those charges to the family. The health regs, when it comes to direct cremation package pricing, requires two quoted. Health reg has two quoted required disclosure statements as part of those pricings. Do they have to be listed verbatim, or can language be added to them? So, there's two very specific disclosure statements that are required in the reg. They have to be verbatim. If there are other things you want to let the consumer know about, just add it as a separate disclosure. Don't add it to those disclosure statements, or you could be deemed in violation of the regulation. Can a funeral director put an upcharge on their GPL for Saturday and Sunday services? So if for actual services, you're charging for supervision, facilities, etc., yes, a weekend charge can be added because basically the family has options. They can do it another day of the week if they don't want to pay that extra charge. Can a funeral home offer scattering services? And if so, can you add it to or should you add it to your GPL? For example, renting a boat and go out on a lake and scatter or place a biodegradable urn into the water. If the family's not going to be present, but record the service and put it on a DVD or flash drive. So in this case, that service would be listed under additional service and merchandise. The thumb drive or DVD would be on the GPL as merchandise. And again, as long as it's clear what you're offering as a service and the price is listed, it shouldn't be an issue. The way it was always described to me from Tom Fuller was, as long as it's not illegal or otherwise prohibited or restricted in the law or regs, you can charge for anything as long as you disclose it properly. Is a funeral firm allowed to add a weekend overtime charge to their GPL? So the Bureau said that there's not a specific regulation or policy on this, and they have generally allowed reasonable charges for off-hours scheduled services where the family has the option of choosing a lesser costly time. There's not overtime or off-hour charges are not allowed for responding to the initial call for service as stated in the past. So this is not something you could add as a charge for responding to the initial call, but if it's for scheduled services, disclosed, family has the option of choosing something else, then it is permissible. If both prices on the GPL, if both prices are on the GPL, can a funeral home have a different price for an online cremation arrangement versus if the people come into the funeral home for an arrangement conference? So the easy answer to this one is no, and the reason is you can't distinguish prices based on the method of making arrangements. If you do it either way, doesn't matter, same price. Okay, we have just a couple questions left. A funeral home received a request for their general price list so that an organization can compile a price comparison with other funeral homes in the county. Do they have to share their GPL? Does the answer differ if the request is left on a voicemail or through an answering service? So this one involves the FTC's funeral rule, and in the funeral rule guide, it states, and you can see the quote here, that you have to give the general price list to anyone who asks in person about funeral goods services or prices. And you have to give the GPL for them to keep. It does not have to come from a consumer or someone who wants to make funeral arrangements now in the future. So an in-person request, even if it's not someone who's going to be asking for services, like say this company showed up at your door, then you have to give them the GPL. If you have pricing questions posed to you on the phone or email or mail, you have to answer it, but how you answer it is up to you. You can give them a copy of the GPL, or you can just kind of generally answer the very specific question in a way that gives them information about the pricing. And our last slide is a scenario. A funeral home already has custodial care listed on their GPL. The firm just added a refrigeration unit and would like to add it as a separately listed charge. Is this permissible? So you can charge for one or the other, but not both at the same time. The rule is that you cannot charge custodial care on any day the body would normally have been there and incurring charges already, i.e. visitation, embalming, because those are separately charged items. Same applies for refrigeration. The body would have to be in the refrigerator incurring a charge, so it cannot be charged twice. So that, you can see some of these questions was us posing them to the Bureau, after we received it from the funeral home, because many of these were so specific that it wasn't something that we felt comfortable without some backing from knowing the Bureau had their answer, and also being able to cite health reg, health law, FTC, funeral rule, things of that nature. So that concludes the list of questions for the Compliance 101 webinar, and we can now open it up to any questions.
Great, thanks, Mike. And I want everyone to pay attention to that number that's on their screen right now. Again, you may be asked for the number you saw in the beginning and the number you can see right now to verify your attendance. Okay, so now if you have any questions, everyone knows by now, type them in the question box and we will get to them. So I will start with question number 1. And this is regarding the agent form. A funeral director asked, how is it not considered a legal document that is not required to be completed by an attorney? Who is to say when we as funeral directors are provided this form that it was officially signed by true witnesses and not the agent, by true witnesses, and that the agent form has not been forged? Is there a time frame that this agent form is not valid? For example, the day before the death.
So there's nothing in the law that talks about the timing of when it's done. Clearly, it's got to be before the person passes. The only time that we've had issues is when someone else from the family comes out and then accuses the agent named in the form of having forged this document, or that, that the person wasn't of sound mind and body and they didn't really appoint this person. In that case, we've always told the funeral home, if you're aware of this dispute, pause, tell them they need to go to court and work it out, and that you're not doing anything until you have a court directing you which way to go. But you are always protected from acting reasonably, and you are allowed to rely on what that person says. So the agent is coming forward and this person is saying to you, I have a form. You're not, signature experts or handwriting experts. So you're not liable if it ultimately turns out that it was forged and you had no knowledge of that or any reason to feel it was or believe it was. That would be action that would be taken against the individual who presented it under false circumstances, and the family would go after them.
Okay. What is the best way for us as funeral directors to accept a waiver of rights? Should it be an affidavit saying such, or what is the best documentation? And then the funeral director goes on to ask if we have a resource as a waiver they could download, which we do on our member side of the website under compliance. Yep. You can definitely go there, but I'll let you answer the first question, Mike.
Yeah, so I think, really it's anything in writing, but as Kelly just said, we put that form together because we think that's going to give you the best protection and it covers everything. So we always recommend that if we have forms available to try to use those if you're able to and get a copy of those. But if it was a circumstance where you didn't have it and they want to put it in an email, write it down. Anything that you have in writing would suffice to protect you if that person is waiving their rights. But the form, I would recommend using the form wherever possible.
Can a registered resident be listed on your funeral home advertisement?
So you can have a resident listed. You have to disclose who a funeral director is and who isn't. So you cannot have them listed. When you put registered resident, we actually had one of these very recently come up and talk to the Bureau, and they felt that that was a little misleading because it doesn't really describe who they are. And they're not a licensed funeral director yet, so you have to distinguish them as non-licensed staff, or you have to, separate if they're on there with licensed funeral directors. You have to indicate who the licensed funeral director is. That's a requirement under the advertising law.
If there is only 2 surviving children living, in regards to the majority rules, does one or both have to sign the written statement, and or the cremation paperwork?
So the way the law reads, if there are only two in a class, two children, two siblings, then you are legally allowed to work with one of the two and move forward, and you only need one. We always say in that situation that we believe it's best to get an agreement on something like that, especially if you're dealing with something like cremation where the process is irreversible. But you're legally allowed to work with just one and only need to have one sign any paperwork. The recent change in law is that if there are three or more, you need a majority. So, for example, if there are 3 kids, you need 2 of the 3 to agree. If there are 5 kids, you need 3 of the 5 to agree. If there are 4 kids, 3 of the 4, blah, blah, blah. So, but when it's only 2, legally you only need 1, but we always recommend trying to get both to agree.
And this is probably a question for the Division of Cemeteries, but do you know if there are any regulations on funeral directors serving on a cemetery board?
I believe there are. Their board is set up a specific way, just like the Funeral Service Advisory Board, but I do not have the regulations at hand. They might be available on their website. We can try to find that information out and get it out to who's ever asking this question.
Can employees that qualify for weekly pay waive that in writing?
You cannot. You cannot waive that right. That was something that was brought up during a court case on this, and that is not something that an employee can waive. It's a right that for whatever reason it's something that you cannot change or depart from. You have to pay them weekly.
Okay. The next question is really for vital records, but it just talks about asking registrars to be able to work remote on the weekends and certify
right.
death certificates and things.
Yep.
Which we've talked about.
Mm-hmm.
And then, where is the correct place to put mileage on the itemized contract?
I believe that there's actually a line that talks already, like in the form under the reg, where it has mileage, and then it has the like in parentheses where you put a price at mileage. You would on your GPL say, certain number of miles included, X amount of money for every mile thereafter, and then the calculation is right there. There's a line that's already set in the itemization statement for putting that in. And just a side note, that itemization statement format is it's specifically listed in the regulation. The format, the order in which the things have to be listed is set in regulation and cannot be altered. So you have to make sure that your itemization statement is listing everything in the order that the reg requires.
Can a funeral home set a surcharge for supervision of visitation on a holiday like Christmas or Thanksgiving? Note that the use of facilities charge would remain the same.
That one I haven't don't remember getting. I know weekends we just said that you could have a higher price because you have options. So I would say as long as it's listed on your GPL, that would be permissible because they have options to choose other dates that aren't the holidays. So I would say it's permissible so long as it's disclosed because it would be akin to weekend services, selecting weekend services and paying a higher price.
Can a POA for an individual sign an agent form appointing another individual? Any suggestions for how to prevent liabilities besides the typical paperwork precautions already taken?
So as I mentioned in that one scenario that we had gotten in the question, per the Division of Legal Affairs at the DOH, a POA cannot appoint anyone as an agent, themselves or anyone else. So when someone walks in and says, I'm power of attorney and I'm going to fill out the agent form on behalf of whoever they're power of attorney over, they cannot do that. That is not permissible.
Okay. Can you just confirm that when a concierge service calls your funeral home, you do not have to give out a price list on the phone?
Correct. You do not.
But you do need to give prices if you are specifically asked, correct?
Correct. Correct. How you answer it, whether you want to give it to them a GPL or just answer it, is up to you.
Okay. A new mother who is under the age of 18 loses a child. Isn't she automatically an emancipated minor able to have control of disposition of her child?
She is not, because that specific section of law uses creates the definition of a person for purposes of final disposition, and that requires the individual to be 18 or older. So other rights might exist as it relates to the mom because of the circumstances, but when it comes to final disposition, the law is very clear that you have to be 18 or older, and therefore she would not have the rights to serve as the mom under that section of law.
Can you restate the conditions under which weekly pay is triggered?
Yep. So it is if you are what's called a manual worker under the law, and a manual worker is an individual who is doing at least 25% of their work that is considered, or I should say 25% of their job consists of manual work. And I'm just looking through the slides here to see what manual. So like I know I said in there it was here it is, physical labor. 25% of the time of your employee is engaged in physical labor, which includes common tasks like sweeping, carrying, and standing for long periods of time. So if you have anybody on staff who are working or engaged in physical labor at least 25% of the work week, they must be paid weekly.
Does the fact that licensed funeral directors are licensed professionals cut against the manual worker definition?
So this is funeral home staff. It really shouldn't apply to a funeral director. They would be exempt. So that it's I think the way it was phrased in the question was funeral home office staff. Let me just double check. So the question specific is, does New York require that certain funeral home support staff be paid at specific intervals? So support staff. So those would be the folks who are not licensed funeral directors.
Okay. Are funeral homes entitled to blocking days off from allowing services to happen, such as holidays, as long as a higher fee is not charged on a different day because of the funeral home's choice to not have services on the holiday?
I'm sorry, say the first part of that one again, Cal.
Yeah. Are funeral homes entitled to blocking days off from allowing services to happen, such as holidays, as long as a higher fee is not charged on a different day because of the funeral home's choice to not have services on a holiday?
So if you're going to be closed on holidays or do things like that, then you're a private business. You're not required to hold certain services or do certain things if you choose not to. I mean, a funeral home can decide to be open Monday through Friday from 9 to 7 p.m. and that's how you want to operate, and people will make a choice as to whether they want to use you guys. So yes, you can You can choose not to be open on holidays, certain holidays, all holidays. That's totally up to you.
Might be the end of, yeah, that appears to be the end of the questions. So I just want to thank everyone for being on today. Like I said, if you got disconnected at all and you have not yet reached out to us, please reach out to us so we can kind of connect the dots on that. If you are using the app on your iPhone, again, please let us know in case there's any kind of problems. And give us 7 to 10 business days for your portal to reflect your credit from today. And as always, if you have any questions, you can always call us here at the office and speak with Mike or I. I hope everyone has a great rest of your day, and thank you again, Mike, for providing this for us.
Thank you, everyone. Thanks, Kelly. Have a great rest of your day.